reauthorized the National Flood Insurance Program for the next 5 years, increased loan limits for the VA loans, and reinstated, and the current ARM programs under the VA were made permanent. And you can get more information, again, on the Realtor.org website on all the regulatory and legislative accomplishments of NAR in the last year. Law, state law, septics. I don't have anything to say about septics. We started talking about the proposed changes to septic regulations about a year ago. And specifically why we were brought into it is because of real estate contracts. The way the law is currently written, if a seller sells a property on a real estate contract to a buyer, even if you've done an inspection and you convey a perfectly working septic system, and then the buyer subsequently stuffs Pampers down it, and the next thing you know, raw sewage is running through the streets, the environmental department is going to look to both the seller and the buyer to remedy the problem. And the seller's going to say, but I conveyed a perfectly working system. I mean, look, I did an inspection. There's nothing wrong with it. It's the buyer's fault. And NMEAD is going to say, I don't care. Our regulations say you are both responsible. You both have to clean it up. Okay? So that's the way it's currently written. So we went to the MEAD and said, that's not fair. That's not fair to the seller because they haven't done anything wrong. We want you to look to the buyer for the remedy and not to the seller. And they listened to us. They listened and they agreed. So we created some language, some definitions and some language for them that said that it would be the buyer who was responsible upon equitable transfer. The seller was no longer the owner under the definition. The other issue that came up is that I get this question quite frequently, is everybody knows that you have to do an inspection on your septic prior to transfer. And the question was, is that equitable or legal transfer of the property? And there was no distinction made in the regulations. I would tell everybody who would want to transfer their property from a buyer's perspective, who would want to buy on a real estate contract without knowing the condition of the septic system. From a seller's perspective, if they know they have a good system, they want to they want the buyer to know they have a good system. So why wouldn't everybody be doing it at that time? Why would you wait until 5 years down the line when when the balloon payment is paid and you're doing a legal transfer to do it at that time? By that time, the buyer's had the system for all this time and has been using it. So I would always recommend that it be done at that time, but there was nothing in the regulations that defined when it had to be done, legal or equitable title transfer. So we cleared that up, and it does have to be done at the time of equitable title transfer. Okay. I know you guys are still having trouble with banks with the septic system, and unfortunately there's nothing we can do about that because in the regulations, because there's already a regulation that addresses it. The sellers are supposed to do inspections, so your banks that won't and don't do inspections are in violation, and you should call the New Mexico Environmental Department and tell them that they're refusing to do their inspections. We don't need another rule, we just need that one to be enforced, and for them to actually start going after the banks and saying, you can't transfer your properties without doing this, okay? Because I know that is an ongoing problem. In a scenario where, that's not going to get you any immediate results. You're having to deal with a transaction right there, and it might not get you any immediate results. What do? And I tell everybody that the buyer should just pay for the inspection. The buyer should know what they're getting and understand, because that can be very, very costly if you have a failed system. So they need to understand what they're getting into. I mean, at the end of the day, if they say, I don't care, I'll just take my chances, I would certainly have them sign off on something that you guys create saying, my buyer advised me to go ahead and pay for this and get an inspection done, and I've decided I'm not going to do it, and stick that in your file. So if they ever come back when the system fails and they find out they've got $10,000 worth of work to do on their septic system, you've got a piece of paper saying, hey, I told you so. The told you so paper. Okay. I guess I did have something to say about septics after all, didn't I? Okay. Title insurance update, effective 10/1 this past fall. They made some changes to the regulations. Title insurance is regulated by statute, by law, and then it's also regulated by the superintendent of insurance who passes regulations. And then they have promulgated forms and rates, and they have a biannual hearing where they make changes if necessary. They had a rate change this past fall. The cost of a title commitment went from $50 to $100. And the basic title insurance premium rates increased by 2.5% for any policy issued after the effective date, which was last October. They also have a new thing for surveys. Have you guys seen this? Yeah, okay. So the standard exception number 3 excludes from coverage those matters which would be shown on a survey, such as encroachment, overlaps, conflicts in boundaries, et cetera, et cetera. Prior to the changes, what was required to delete that exception number 3 were for refinances, they could rely on an existing ILR or survey, and for purchases, they required a recent survey, which they defined as anything no more than 6 months old. But after the change last October, it allows each title insurance underwriter to define what they will accept as a recent survey. And the key here, everybody, is to know what your title company is doing, because they differ. Everybody gets to make their own rules in this respect, okay? I have a friend of mine who works for American down in Albuquerque, and so he just gave me some idea of what they're doing. For property in platted subdivision up to $1 million, an ILR or survey of any age will suffice if the policy is no more than $1 million, the insured land is written in a platted subdivision, and the owner provides a sworn affidavit saying that nothing's changed, okay? We are building language into, where is Gavin? There he is. Into our form, our purchase agreements to kind of address this survey issue. It won't be out for a little while, so you guys might want to take a look at that, you know, and just make it clear. And what we're going to try to establish is, for example, will a borrower accept an existing if the title company and the lender will accept an existing? You know, even though, and if not, then you have to decide who's going to pay for it. But there's no need to get another one if the lender and the title company don't need another one. So we're going to be addressing these issues in the forums. We're working on that right now. For a platted subdivision between $1 million and $5 million, or unplatted property up to $5 million, a survey, not an ILR, of any age will suffice. If the policy coverage is not more than $5 million, the owner again provides a sworn affidavit, and it can be supplemented with a current ILR. It can't be the only thing you use, but it can be supplemented. That's the other issue we're going to be dealing with in the forums, is this sworn affidavit. When are you going to get that? When does the seller have to provide that document? You don't want to wait till the day of closing, because for some reason they don't want to provide it, or they can't provide it the day of closing, or they look at the language and go, well, actually, we did build a wall, or something significant that would create a problem. You don't want to know that the day of closing. So that's another issue we're dealing with. When does that sworn affidavit have to be delivered? For policies over $1 million, a survey and not an ILR, less than 1 year old, and the owner provides a sworn affidavit. But again, every insurance company is different, so check with the title companies that you work with. I will make one mention about title companies, since we're talking about title companies. And who gets to choose the title company? The buyer. Can the seller dictate which company is used? Ah, yes. If he wants to pay for what? All title company fees, lender policy, owner policy, and all associated fees, okay? I know that a lot of MLS listings have in there that the seller wants to use a particular title company. I don't see a problem with that in the listing, as long as it's clear that it's a preference. Seller prefers to use XYZ title company. Just don't make it look like it's a condition of sale. And it can never be a condition of sale unless the seller is willing to pick up all those fees. There's some debate and some disagreement. There's one particular attorney up here in Santa Fe who doesn't agree that you have to pay both the owner's policy and the lender's policy. That's his position. Arizona actually got a letter from the government on this one, and it was clear that you did have to take care of both of those fees. Insurance update forms, they said that the new regulation prohibits changes to the promulgated forms, and it allows the promulgated forms in other languages, though English language version controls the legal effect, meaning they're going to look to the English language form to when they're in court to determine what the contract means. There's a new Form 85. It's intended to deal with the unmarketable titles resulting from the land grant claim. The superintendent has to specifically authorize the insurance, and they've not done yet. It's a cost of $100. And it allows them to insure around these go ahead and issue insurance up in Taos, for those of you who are not familiar. One of these guys who claimed he was a partial owner in this land grant, that he was given all of this through this land grant. He was given all this property, went down and filed deeds on how many properties was it, John? Do you remember?
45,000 acres.
45,000 acres affecting, I don't know, thousands of property. Yeah, thousands of properties. Clouded the title on thousands of properties. Yeah, it was a nightmare. And the title companies wouldn't insure on them, and they couldn't get them sold. And so we've kind of been trying to deal with this for, since that happened, which was how long ago now? 2 years it's been already? This isn't, this is up in Taos right now, but it's not just Taos. I mean, it affects their land grants all around the state. So it's not just that area, it's just that they've been, and evidently Ojo Caliente right now. So anyway, they did create this new form, and they did allow for this insure over, but the superintendent has to officially authorize that, and he hasn't done it, and I've been told the same thing. I've been told he's not going to do it, and no, I haven't heard why he was refusing to do it. I mean, and we did have a bill last year that we tried to get passed that the governor wouldn't sign, and it addressed this too, but she felt like there were already remedies on the books to deal with it, and didn't feel like it was necessary to create another law. So we're still working through this issue. So for more information on title rates and the forms and the regulations and everything, you can go to the PRC website or to the Land Title Association website and take a look at anything you need to know about title insurance. I want to talk just for a second on the foreign broker law. Currently in New Mexico, we have a foreign broker agreement. If a broker comes into our state and wants to do business in our state, they have to enter into a transaction-specific written agreement with a New Mexico broker. And then everything has to flow through that qualifying broker, and that qualifying broker is on the hook for everything that foreign broker does. That foreign broker has no obligation to register with the Real Estate Commission, and the Real Estate Commission is not looking at that foreign broker. They're looking at the qualifying broker with whom they've associated, okay? Currently in other states, Arizona has a kind of a similar law to us. Colorado has what's called a limited license recognition. And what this means is that you have to have a Colorado license to do business in Colorado. You cannot do anything in their state except accept a referral fee if you don't have a Colorado license. They do recognize licenses from other states to the extent that they don't require you to take the national portion of the test when you go to get your license in Colorado. They also give you some credit for classes you've already taken down in New Mexico, but you do have to have a Colorado license, so you can't do any business otherwise. Texas, and I don't want to pick on Texas, but they don't let you do anything in their state at all. They don't and they don't do limited license recognition. So if you go to Texas, to do any business in Texas, you have to have a Texas broker's license. You have to take every bit of their exam. You don't get any credit for anything over there. And otherwise, you can do no business in that state at all. None, okay? I've gotten a lot of complaints from mainly the south and southeastern part of our state, talking about how, mainly Texas, again, hate to pick on Texas, but evidently the brokers are coming in and kind of pushing our brokers around. They're saying, this is the deal, I got a seller, I got a ranch property, I got a commercial building, and this is the deal, you're going to take the deal, I'm going to do all the work, I'm going to put my sign on the property, I don't want you involved. And, the QB, no, but eventually they find a QB who says, okay, I need the business or whatever, and they let them do it. I had a problem with that. I just don't think that's right. I mean, why do we make it so easy for them to come to our state and do business, and they make it so hard for us? We had a broker down in that area who wanted to manage a property over in Texas, right on the other side of the line, and they couldn't do it. Well, so, I just didn't think that was right. So I started making some noise, and the Real Estate Commission is going to do away with going to try to do our way. I mean, I can't say it's going to pass, but they have introduced a bill during this session to do away with our current foreign broker statute. So there will be no foreign broker statute, which would allow them to come in and work as a foreign broker. They would have to get a New Mexico license. We are going to do limited license recognition, which I know is more than Texas does for us, but it was just too difficult to figure out, okay, if we treat Colorado like Colorado treats us and Texas like Texas treats us, we'd have 15 different or more different ways that we treat the brokers that come in